Today we're going to be talking about parole revocations, and mandatory supervision. Now, as a criminal defense trial attorney, oftentimes we don't talk about or consider parole aspects that often. Many people assume a defense attorney's job is simply about guilt or innocence going forward, but that's not the full reality. A criminal defense attorney has a wide spectrum of what they need to entail. I like to kind of think of our job as being able to help you out and get you out of the situation you find yourself in with the least amount of harm. And sometimes that requires taking into consideration parole. For those of you who don't know, parole is kind of like an early release from prison. If you find yourself sentenced to a prison term, based upon your time credit going in and awarded while in prison, you may become eligible for parole. What that entails is, a normal parole eligibility date typically consists of your flat time plus your good time. When that is equal to 1/3 of your total sentence, you are eligible to be heard for parole. Now, your flat time is going to be considered your calendar time, or your day-for-day time spent in prison. That will also include any time credit you have from jail sentences awaiting before you go into prison. While your good time is going to be time credit earned for doing like work while in prison, or good behavior, or credit for class time that you enroll in. You get awarded for the steps you take while being in prison. So based upon that, if you're given like a 10-year sentence, you would become eligible for parole roughly about the 3.5-year marker. So when your flat time plus your good time is equal to about 3.5 years, you'll be eligible for parole. In reality, that would probably be around 1 year and 2 months in. Now, there's also this grand scheme called mandatory supervision. Now, mandatory supervision is kind of a misnomer because although the name says it's mandatory, it is still discretionary. So it's kind of a discretionary mandatory supervision. You'll qualify for that around the time period when your time credit, your flat time plus your good time, is equal to the entirety of your sentence. So based upon a 10-year sentence that you've been awarded, when your flat time plus good time is equal to 10 years in total, you would be eligible for mandatory supervision. There's a lot of considerations that need to be taken when you look for a parole representation going forward. A lot of things the parole board look at will be your offense that you've been convicted of, your prior history, what you've done since you've been incarcerated, and a lot of other great steps and avenues that can be taken to increase your chances going forward for a favorable parole vote. That's why it's important to try and hire an experienced attorney going forward on parole. A lot of my clients that I've dealt with going forward on parole have hired other attorneys, and they feel like they've been cheated in the system. They feel like they haven't done much other than just prepare a simple packet of support letters and submit it to the board. If I'm handling your parole case, I like to spend as much time as I can with you to help build a case going forward together. I get family members involved, and I have a personal one-on-one meeting with the actual lead voter in your case. I try to make the best possible information to that board so that they are fully aware of the full circumstances going forward in your case. It is much more, every parole case in my opinion is much more in depth than the actual crime itself that's been committed. But in fact, you have to look into the full situation, the whole socioeconomic evaluation of the client, what led them into that part of time, any kind of mental illness or things like that. My time handling parole cases, I try and do it in a 2-step evaluation. The first step is going to be a case review fact pattern, and then the last step will be the actual presentation itself. I have often found myself doing the full case evaluation. I find that there are better avenues to go, whether it be a better appeal avenue that was overlooked, or a writ opportunity that was also maybe just not glanced at properly by other attorneys. In doing this full evaluation, I can oftentimes find and better assess a better result for the client. Which leads me also now to kind of talk about how the parole board system voting works. There are 7 different parole board commissioners, or parole board jurisdictions across Texas. You have various board locations such as Amarillo, or Angleton, or Austin, in Huntsville. Each board location is consisting of 1 board member who is considered the lead voter and 2 commissioners. Every time a case is heard by that board, you have to have 2/3 or a majority of the panel voting on your case to give you a favorable vote for you to make parole. The way it works is one person becomes the voting person who will evaluate the case, make a report, and issue their findings to the other 2 people on that board. It requires 2 of the 3 to say yes in order for you to be favorably voted for parole. There's also a type of case that's going to be considered called SB 45 cases, or Senate Bill 45 cases. These are cases that are the more extreme measures. It's going to be your capital cases or your repeated sexual assaults of a child, things of that nature that are egregious by definition. On an SB 45 case, it requires the full board members, all 7 board members, to actually vote that case. Each one will have to have their own input, and it's going to require a 2/3 vote again for a favorable parole. So that would take 5 of the 7 board members to vote favorably to grant you parole on an SB 45 case. And again, all of this information applies strictly to Texas parole laws. The federal system used to have a parole system in place, but that has since been done away with. Now they just follow a thing called the Federal Sentencing Guidelines, which will be touched on a later video. Now going forward, I have mentioned quite often about jail time credits and things like that. Now the original sentencing from a judge on a court of law, it's his discretion whether or not he will give you jail time credit. It's very common that a part of plea bargaining and things of that nature, they work out so the prosecutor will offer you a sweet deal, but will do away with your applicability of getting any kind of jail time credit from time already served. It's important that you have a qualified attorney who is very familiar with both parole law as well as Texas law to kind of help assess and evaluate your criminal case. If you or a loved one is currently incarcerated in prison and is looking for parole representation, reach out to an experienced attorney. Here at Parnham and Associates, we have dealt with numerous cases involving parole law as well as parole representation of clients currently incarcerated. Give us a call today. Thank you.